So in this second presentation, I would like to present to you an important case we had recently in Belgium, and this case is about enforcing biodiversity law through the use of criminal law, and this with the involvement of environmental NGOs. Under Belgian jurisprudence, and this is quite recently, it's a judgment of the Supreme Court it's called the Court of Cassation of 11 June 2013. Environmental NGOs can act as civil parties in criminal proceedings. And on the slides you see the main reasoning of the Supreme Court. So the Supreme Court said that according to the Criminal Procedure Code, the legal action to repair damages belong to the victims, and they shall demonstrate a direct and personal interest. So this is, let's say, case law from all times. But then the court added they shall demonstrate when such an action is introduced by an environmental NGO and aims to challenge acts and omissions that contravene environmental law, such an environmental NGO has a sufficient interest to do so. And this with reference to the Aarhus Convention, in particular Article 2 and Article 9, Paragraph 3 of that Aarhus Convention. So this is a important new development in the case law of the Supreme Court in Belgium, and I will try now to illustrate this. So because a civil party has important rights in the criminal proceedings, both in the pre-trial proceedings as during the trial proceedings. So during the pre-trial proceedings, a civil party can trigger a criminal investigation, has access to criminal files at various moments, can also ask for additional investigation actions, and is inviting to the hearings of the investigation tribunal in the course of the investigations. And at the end of it, to sum up, such a civil party has a sort of watchdog function to keep the investigation progressing. The civil party has also rights in the trial procedure, so the civil party can be represented before the criminal court alongside the public prosecutor, the defense and the accused, and may claim damages and measures to restore the harm done by the criminal acts. So now I would like to illustrate this using important recent case. I will call it the VT case, referring to the initials of the main perpetrator. The NGO involved is Vogelbescherming Vlaanderen, which we can translate as Bird Protection Flanders. It's a regional bird protection organization which is very active. It's a small organization, has only 6 full-time staff members, but has a lot of volunteers, more than 1,000, apologies, and more than 8,000 members. And a lot of those volunteers and members are bird watchers, which go out in their spare time, and you can say these are thousands of couples of eyes and ears that can come across illegal activities, and this is an important factor, I should say. You can find more information on this association on their website. Here you can see the main office of that association. You can see it's not a very large association. What can I say to introduce this case, it's, let's say, the result of a long and intensive judicial inquiry. It included international legal cooperation between Belgium, the United Kingdom, Spain, France, Germany, Austria, and the Netherlands. And the main crime was that eggs and fledglings of wild birds, included red listed under the CITES conventions, so endangered species, endangered birds were stolen in large quantities from the wild. And this happened in remote areas in Spain and France. And these eggs and fledglings were smuggled towards Belgium and were hatched out here in Belgium in captivity. They were hand-reared and they were ringed. And there was also a question of forging of rings and of breeders' declarations. So here you can see the Monfragüe National Park in Spain. These were one of the places where the crime, the initial crime, happened. And you can see there are a lot of birds over there. On this picture you can see how these eggs were transported from France, from Spain towards Belgium. Here you can see the forging of the result of the forging of rings, and here you can see the material which was used to forge these rings. The birds concerned are a whole bench of very nice and protected birds, which are really also endangered. So, for example, Egyptian vulture, African fish eagle, imperial eagle, bald eagle, Bonellis eagle, golden eagle, booted eagle, also different types of peregrine, marlin, hobby, falcon, kite, different types of kite, bustards, owls, snowy owls, etc. And here you can see some of the pictures of the type of birds which were concerned by this crime. So very nice birds. And when these birds were grown up in captivity, they were sold to bird holders in different countries, in the UK, in the Netherlands, in the Czech Republic, in Germany, in Belgium too, of course, etc. And this business seems to be extremely profitable. For example, it seems that the market price of a Bonellis eagle is 10,000 euro, a bald eagle 5,000 euro, an African fish eagle 6,000 euro, a bootled eagle 5,000 euro. So the court, the criminal case came before the court of first instance of the criminal court in the city of Ghent in Belgium. 4 persons have been incriminated, and the charges included 504 facts of forgery of CITES documents, which is a violation of the European Union CITES regulation and some of the complementary domestic legislation. 522 facts of the use of these falsified documents. Also being part of a criminal organization, also violation of CITES exportation provisions, and also there was question of money laundering. So the judgment of the criminal court of 27th of June 2014, taken by this court, resulted in the fact that the 4 defendants were declared guilty, and in a very huge judgment, over 300 pages, they were declared guilty of the different CITES-related facts, also guilty of participation in a criminal organization with branches in various countries. And also the leading defendant was convicted for money laundering. And on the slide you can see one of the more stronger motivations of the reasonings of the court, saying the defendants committed a direct and irreversible assault on biodiversity, and for profit the defendants seriously undermined national and international efforts to preserve and protect these already vulnerable bird species. What was the sentence? Imprisonment 4 years for the main defendant, of which 1 year conditional, 2 years of his main aid, of which 1 year conditional, and then 18 months and 1 year for the other defendants. Also fines were imposed, 90,000 euro for the main defendant, 30,000 for the second one, and 12,000 for the third one. And what is very important, there was also confiscation of the illegal gains of the trade, as explained earlier. This commerce is very profitable, and the total amount of illegal sold birds amounted to nearly more than 800,000 euro. And the birds were seized and confiscated and entrusted to the remaining birds to the Belgian CITES authority. Referring to the earlier mentioned judgment of the Supreme Court of 11 June 2013, the Bird Protection Organization was recognized as a civil party, was awarded €1 compensation for moral damages, €250 compensation for material damages, and compensation for litigations cost. And this was a little bit disappointing for this environmental NGO, because this NGO was claiming €15,250 for damages. So this issue has been discussed again in appeal. So it must be said that the court in Ghent, which has a very good track record for enforcing biodiversity law, has on the other side as jurisprudence that the environment belongs to everyone or to nobody, and that harm to the environment cannot result in real moral damages, only some symbolically by awarding this €1 compensation. So the case was appealed before the Court of Appeal in Ghent, and this resulted in a first judgment of 7 May 2015, which was pronounced in absentia of the 2 main defendants, and they have meanwhile formed opposition. I will come to that. And their case was heard again. The judgment of 7 May 2015 of the Court of Appeal confirms in all aspects the judgment of the first court, and the compensation for moral damages that should be paid to the Nature Protection Organization has been increased from the symbolic €1 to what was claimed by that NGO, €15,250, and the interests. On opposition, a second judgment followed for the 2 main defendants, and also here we have to do with a very huge judgment, more than 320 pages. And also now the first judgment has largely been confirmed. As the sentence are concerned, the imprisonment was stayed 4 years, but became 2 years conditional instead of 1, as has been decided by the first judge, and the fine had been increased to 90,000 euro. Also, the confiscation took place of illegal gains of the trade for 835,800 euro, and the cost of procedure had also to be paid by the convicted, and has been risen meanwhile to 50,120 euro. The compensation for moral damage that should be paid for the nature has been confirmed. So of the first judgment of the Court of Appeal. And meanwhile, the court could refer to a judgment of the Constitutional Court of Belgium, which I'm a part of, who had to decide about this interpretation, how to interpret the provision of the civil court dealing with fault-based liability, Article 1382. If bird protections organizations of environmental NGOs can only claim 1 symbolic euro and others can claim more, is that not a discrimination? Is that not violating Articles 10 and 11 of the Belgian Constitution? And the Constitutional Court has confirmed this point of view, saying when this article is interpreted in such a way that environmental NGOs can only claim 1 symbolic euro as compensation for moral damage, that would be discriminatory. This will violate the Articles 10 and 11 of the Constitution. So here you can see the operative part of that judgment of the Constitutional Court, saying on the other hand that provision of the Civil Court does not infringe the Articles 10 and 11 of the Constitution, whether or not read in conjunction with Article 23 and 27 on the Constitution, that's about the right to the protection of a healthy environment and the right to associate, and Article 1 of the first additional protocol of the European Human Rights Convention, in the interpretation that it does not preclude to grant to a legal entity pursuing a collective interest, such as the protection of the environment or specific components of it, a compensation for moral damages to that collective interest that goes beyond the symbolic sum of 1 euro. Meanwhile, the Supreme Court has also delivered its final judgment in the VT case, a recent judgment of 11 October 2016, and the Court of Cassation nearly dismissed the whole appeal in its entirety. So the final judgment of the Court of Appeal in Ghent is now final on those aspects. The judgment has only been quashed on 1 minor point, and that is the increasing of the sanctions imposed to dispose of the main perpetrator on her opposition, which is not allowed. So with this, the case has been terminated, let's say, and I hope I have illustrated with this case first that biodiversity crime can be organized crime and be a cruel form, let's say, of crime, and secondly, that judges should take serious this crime, and third, that environmental NGOs can play an important role in the prosecution of those cases. So I thank you for your attention, and I wish you much interesting discussions during your training session the rest of the day. Thank you.